2. This case system. What lies behind the case? A law school, setting up a course of study, must face two different jobs. In part, they overlap, but they cannot be assumed in advance to coincide at all. The one job is to discover what you need in order to practice your profession, to pick out such parts of that equipment as are either most fundamental or best teachable in school, and to devise means of getting these things across to you. The second job begins where the first leaves off, and begins irrespective of how well the first is done, and is a problem peculiarly of the first year. Granted that the curriculum is, wisely or unwisely, to take a given line. What do you need to know in order to handle, not the practice of law, but the practice of law school? In part, I say, these two problems overlap, and it is well they do. But I am concerned today but little with their overlapping, or with the first, the long-run job, save as a passing reference to it may shed some light upon the other. The question today is immediate and intensely practical. It has been decreed that you are to study law largely by the case system. What do you need to know to make that study go? I warn you again that you will find my words empty, find them even likely to mislead, to the extent that you have incurred the danger of a little knowledge. But the concrete basis is already being provided day by day in your assignments and your use of the case books. It will pay promptly, therefore, if you follow. Certain it is that students who are simply pushed off the dock into case method study flounder rather longer than if they have some inkling of the underlying theory. For however different the methods of your various instructions are, and they diverge amazingly, there are some theories common to the teaching of them all. I shall discuss first what the so-called cases are, and in that connection, I shall sketch our judicial system far enough for you to place the so-called case a little in its setting. That done, it will be time to turn tomorrow to how the case is used in class and out. A case, it is obvious, is made up for lawyers not of a dozen bottles, but of a dispute, and the term case hardened is to be read in this connection. But for purposes of the case system, not every dispute will be a case. We deal with law, and it must be a case at law, that is, a case in court. Even when fancy ranges, and we put this case or that for your discussion, the fiction of the case class is always that the case supposed has come before a court. But again, there are two kinds of courts: trial courts, or as they are also called, lower courts or courts of first instance, and courts of review, i.e., appellate or upper courts. Now a case never reaches a court of review until it has first been through a tribunal of trial, else there would be nothing to review. But the cases so called in your case books are almost exclusively chosen from courts of review. To understand them, therefore, you must get at least some quick picture of what has gone on before they got there. Before attempting that sketch, there is one thing to hammer home, to orient the sketching. A court of review has as its business of review to listen to complaints that a lower court has done some job improperly, i.e., as the phrase goes, has been in error, has made some ruling not in accord with the rules of law, correctly understood. That, and that alone, in legal theory, will come up for decision. Did the trial court, in the points complained of, act according to the rules? Has there been error in those points? It is essential to grasp this theory, and to grasp it firmly, and to work with it till it has become familiar, before it pays to try to criticize it much. Hence we turn to the trial court to look over what it does. Our eye is out for the type of thing the losing party may later accuse it of having done against the rules. In the first place, the trial court may not be the proper court to try this kind of case at all. There are rules about that, rules dividing the power to try cases among the various trial courts of the state and of the country. Those we call rules of jurisdiction of courts. Some courts, for instance, such as the municipal court in New York City, can as a rule take on a case only if it involves $1,000 or less. Other courts, such as the federal courts, when the only ground for bringing the case before them is that the parties are citizens of different states, can handle only cases which involve $10,000 or more, or, as of 27, a $75,000 amount in controversy for such diversity jurisdiction, which is one type of subject matter jurisdiction, And so it goes. Some of the rules seem arbitrary. Some seem very sensible. Like all rules of procedure, they aim to get business done more quickly and effectively. Convenience, efficiency, and fairness are their aim. Like all rules of procedure, they tend to degenerate into red tape. In any event, the court must be the right court, or at least one of the right courts for the kind of case. A court of review can inquire into that. And second, the trial court must have power over the defendant, or personal jurisdiction. We rarely need to worry about power over the plaintiff. He wants action, he comes in, he submits himself. The defendant, however, may want delay, or he may, as some people sometimes do, distrust the particular court, or it may be inconvenient for him to stand suit just there. And as to this, the theory of our law seems in the first instance to be based on the idea of physical power to coerce. If the defendant has goods or land within the territory inside of which the court can act, or if an officer of the court can find the defendant in that territory and summon him, in which shows that he might at need have taken him in by the neck, or if the defendant submits, then the court has jurisdiction enough over him to go ahead. Into this, too, the court of review can inquire. These matters have been mentioned only to get them out of the way. We now assume that our trial court has jurisdiction both of the case and of the parties. We turn to inquire what it does with both. In the first place, it informs itself of what the row is about. This is accomplished in one way or another by the pleadings. To bring his case, the plaintiff's lawyer must prepare a statement of what he claims to be the facts, and of what he wants from the defendant. This is the complaint, the declaration, the petition, or the bill. First, the facts, the statement of his cause of action. And second, what the plaintiff wants, his prayer for relief. Please note these things. They go to the root of any understanding of a case. They must become a matter which you look for as automatically as you blink your eyes when a June bug buzzes at them. But experience shows that the plaintiff's statement is not at all there is to say. Some of the plaintiff's so-called facts the defendant wishes to deny. Some other matters, which change the color of the picture, and on which the plaintiff kept his thumb, the defendant wishes to assert. As a price for letting him do these things when he needs to, which we do by letting him put in a so-called answer to the plaintiff's complaint, we have to take the risk that he will seize upon the answer merely to make trouble. To deny what is so, to assert what is false. Just as we must risk false claims by plaintiffs, if just claims are to be allowed. In any event, sooner or later, we come to an issue on the facts, or to a set of issues we know what facts are in dispute. Of course, this process is not the simple thing that I have made it. Like all procedure, it is a technical affair. And either lawyer may slip, and the court may make rulings right or wrong upon these technicalities. And these rulings may be presented for review. And one other thing must be noted, here and throughout. We have not thus far, you will have noticed, found out anything definite about the facts of the original event, about what really happened. We have the plaintiff's statement, we have the defendant's. But both may be mistaken, both may even be lying. The things that happened are not yet before us, and they may never be. Again and again, we shall find courts of review testing the legal significance, not of what happened outside to the parties, but of something that may be assumed to have happened outside. Testing the legal significance of, say, what the plaintiff claims in his complaint, or of the most favorable inferences for him that can possibly be derived from the evidence he brings in. This, and this too, is basic to our understanding of the cases, is because our system of law lets the parties fight their own battles in the main. What they do not claim, they cannot have. What they do not or cannot prove is irrelevant to the court. It is to the court as if it never had occurred. Let them make their own cases. If they are fools, then leave them to their folly. This, I say, is basic to an understanding of the cases. It is no less basic to an understanding of your responsibility as an advocate. You must become a good technician. When you slip, it is your client who falls. So in our trial court, we may find the defendant not raising an issue on the facts, but saying to the court by demurrer, or by motion to dismiss, Even if what this fellow says is true, it makes no difference. Those are facts of which the court takes no account. There are such facts. A green and pink checked jacket may offend your eyes, but you cannot do anything at law against the wearer. And there are words which he may call you which will burn your collar, without the judges catching fire at the sparks. Or in a more technical day, whose marks are with us still, the defendant may have said to the court, even if this fellow's facts are so, they entitle him not to what he asks for, but to something else. He has chosen the wrong form to bring his action. You have this in a mild form in the family. Peter, I will not listen to you when you whine. John, this is neither the time nor the place. See mother after dinner. These rulings do not, in one sense, go to the merits. They are not rulings on what will be done if all the proper etiquette is once observed. But they affect the outcome, and we shall, later in the trial, find rulings of a similar character. When the evidence on one side or on both sides is all in, it may be claimed that, even indulging all inferences in favor of an opponent, his facts will not touch the court or induce the action he desires. So the motion for a directed verdict, or for a non-suit, or, in modern phrasing, for judgment as a matter of law, or, especially before trial, for a summary judgment. And finally, the same type of fact assumption appears when objection is made to evidence as immaterial. Even if true, it makes no difference. Therefore it is to be excluded as cluttering up the place. And any of these rulings, when appealed from, when re-examined by a court of review, give us light on what courts will do, and on what a lawyer must do. They help show whether the facts assumed really occurred or not, what the court would or would not do if they had occurred. What facts have importance to courts, and what not, and for what purposes. But I must come back to my trial court and my issue on the facts. Here are our plaintiff and defendant, with their divergent stories, and the judge has settled that the outcome will be different according to whose tale is believed. How to determine who is to be believed, and even before that, who is to determine. Solomon, you remember, did it himself. A king, and so a judge. In somewhat similar fashion once in England. Shortly, however, a king has other business. The job got delegated to king's representatives, the judges. And after some centuries for use breeds right, use breeds exclusive privilege, the king found that he could no longer intervene. The relics of this situation, of this turning of decision over to the judge, we too still have. In admiralty cases involving ships where there has never been a jury. Nor is there in equity cases which trace their roots back to the Court of Chancery, which came into existence partly to cure some troubles that the common law courts were caught in, due to jury trial. Finally, when for one reason or another the parties do not want a jury, and are content to take the court's decision on the facts, or in the petty courts in which men think it does not pay to have a jury. In all these cases the judge hears the two stories, and the judge makes his own decision as to what the true facts may have been. But it is still the common practice, in some states, and at least a common practice in all, for that job to go over to a jury. And what is important for us, whether the jury is called upon in a particular case or not. The one-time regular presence of that body has left its marks all over the way the trial court works. It is not my present task to weigh the jury as against other possible machinery for deciding on contested facts, nor to take up the origin of the jury in a group of men from the neighborhood whom gossip and keen knowledge of their neighbors had made aware of most that had gone on. A body who did not try facts, but were summoned to supply from their own heads the needed information on what the facts were. It is not my task to trace how that body of knowledgeable persons turned into the impartial, blankly ignorant jury of the present day, who begin knowing nothing, and only reach their decision upon the conflicting tales of the contestants. I do not know the detailed process of the transformation, nor am I sure that it is known to anyone. My task is much simpler. It is to hammer on the fact that the jury are and have been with us, that they are a lay body and never lawyers, that they begin the trial in ignorance, but make the decision about disputed facts, and then to hammer on certain consequences which have come to cluster around these three things. In the first place, this introduction of a lay body into the court, in this form, splits the court. We are left with a judge to preside and to speak the law, but with a jury of laymen to decide on facts. A jury of laymen, whom judges often did not trust too far, and whose action they have through at least 2 centuries sought somewhat to restrict by an intricate sieve of rules. Because the jury are laymen, not trained in weighing evidence, not case-hardened by legal experience, they must not, save in peculiar cases, be permitted to hear mere statements of opinion, nor to hear repetitions of reports about events mere hearsay, lest they be led unduly into inference. Because the jury are laymen, untrained in sifting issues, not experienced in legal nicety, the common law trial must be confined to a two-party trial, one against one, a supposedly simple type, and must be reduced if possible to a single, precise issue. Because the jury are laymen, but must pass on the facts, it is necessary before they render verdict to charge the jury, to instruct them on the law, and the judge's instructions to them must conform to the rules of law. And much of our study will be taken up with re-examining such instructions when complained of by the losing party. And because the jury, after hearing the instructions, brings in most cases only a single shotgun general verdict, we find for the plaintiff in the sum of $1,400, or we find for the defendant. It is almost impossible to know whether they paid any attention at all to the instructions, whether they even understood them, so that much of our study will be spent upon the learning of an etiquette of instruction, which must be executed well-nigh letter perfect by the winning lawyer, if the verdict he has won is to be proof against appeal, but whose value to the community is strangely dubious. Finally, because the jury is a body of laymen to be informed, but lacking organization or experience for extracting information, a mighty forward thrust is given to our system, I have already mentioned, of party presentation, of leaving the heavy burden of the conduct of the trial, the main control of trial discretion, the choice and handling of the evidence, in the hands of the two lawyers. Our system, often called the adversary system, in short, of making the trial in good part a battle of strategy and wits, a judicial duel between counsel and may heaven help the client. Now let me break in upon myself quickly, to avoid misunderstanding. I have spoken of consequences which clustered about our jury system. I have not said that these were consequences inevitable upon the introduction of a jury, or inevitable upon the type of jury that we know. You have no understanding of a causal sequence in society if you know merely that B has followed upon A. You need to know also why it did not persist. You need to know also why it was B, not C or D, which followed A. It is not enough, either, to know that A has shown at other times a tendency to result in B, nor even that A alone is enough to produce B. You must know also why other twisting or balancing or negating factors were not present which would have substituted X for B. So with this jury, each of the consequences I have mentioned the jury favored. Some, it may be, would hardly have been possible without the jury. None of them is, however, an inevitable consequence. We find on the continent, for instance, juries but few rules of evidence, and the control of the trial much more than with us in the hands of the judge. Nor will it do to wave that off, because the jury there is relatively recent, and the procedure took its major shape before the jury came. For we can compare the present English jury with our own, two shoots off the same stock. The general system of party presentation there has not resulted in eliminating the judge as an important factor in the conduct of the trial, nor has it in the mine run of our federal courts. Indeed, the instructions to a jury can be of great moment, often decisive, when a strong judge moves in a state court to the limit that procedure will allow, in his arrangement, in his emphasis, and in his language, to clear up concretely the bearing of rules of law upon the contested fact situation in the case. Finally, it is surely not the institution of the jury, but primarily the inertia of the human mind, which is responsible for carrying over into trial at common law, even where there is no jury, the limitation to the sharp two-party issue, and for carrying over into trials before the judge alone, even in equity, those rules of evidence which were designed to screen the inexperienced layman from misleading testimony. But whatever the causal sequences, I repeat, the jury has played midwife in our system to a host of consequences. And to those consequences we must have an eye, as, after delays that bear comparison to those at law, our trial in the trial court is finally reached. You will recall that the court is a proper one for our particular case, that the defendant has been duly served with process calling on him to appear, that plaintiff and defendant have duly filed complaint and answer, and that the court is now persuaded that their allegations are of legal consequence. The question is, which one of them can prove the things he claims? We shall pass over the impaneling of the jury, the testing of the prospective jurors one by one to make sure that they are uninformed and free of bias. What of the trial? The plaintiff's lawyer makes his opening statement, explaining to the jury what he intends to prove, and how his side of the case will hang together as a whole. He then proceeds. The handling of the evidence is almost wholly in his hands. He brings in what he wants, what he thinks favorable. He tends quite definitely not to bring in more. There is indeed an interesting rule which works to my mind directly against any theoretical duty. He may have to bring fairly and fully before the court what evidence there is. The rule that a man is bound by the testimony his own witness offers. One will go slowly, with that rule at hand, in making witnesses his own. The plaintiff's proof will be by documents, if he has any which are relevant. Outside of that, it will be mostly by the testimony of witnesses. Whether counsel questions point by point, or lets the witnesses tell their own story, and puts further questions to make clear important points or matters they leave out, depends on him. One thing is clear. The raw events as they happened are not before judge or jury. There has been a straining process. The plaintiff's lawyer has, with an eye to legal relevance, and with an eye to winning, done some selection. Some facts he may himself not have discovered. Moreover, he is by no means wholly free in presentation. There are rules within which he must move, and which the defendant's lawyer will do his best to keep him, or the court, from overlooking. These rules may keep him, sometimes, from proving vital facts. Each time that such an issue on the rules comes up, the judge decides it. Each time, the loser can note his exception. Each exception can, if the acceptor ultimately loses, be made the basis for demanding a review. Each witness, as the plaintiff finishes with him, is turned over to the defendant for cross-examination. There may be further points to be brought out which change the whole tone of that person's story. It may be possible, too, to show that his observation was poor, or his memory bad, or his good faith in doubt. He may, for instance, have made prior contradictory statements. Such matters are the focus of the cross-examination. And the jury presumably looks not merely to what the witness says, but to his appearance. Does he look honest? Is her hat cute? As with the plaintiff, so with the defendant. Then the plaintiff again, this time exclusively for the purpose of rebutting what the defendant may have produced. The defendant combines his main case with his rebuttal. Then counsel address the jury first, commonly, for the defendant, then for the plaintiff. Here the job is to analyze the testimony as a whole, to put it together, to stress the points which speak for you, to slight or explain away those which do not. In a word, to persuade that your story is the right one. The judge then gives his charge. In most state courts he may not comment on the evidence, and thus risk undoing all the work of counsel. That would offend the rules of the judicial duel. The jury gives its verdict. I have spoken of the judicial duel. The figure has not all the accuracy one might wish. In our courts one misses often the courtesy and the grave dignity which seem to have been common in the duel. Nor do both sides start even in the courts. Charles E. Clark speaks neatly of the handicapping of the one side or the other by practices and rules, built as are all-wise handicaps out of judgment based on past experience. The first great handicap rests on the plaintiff. He carries the burden of proof. That is, he carries the burden of bringing in evidence enough to let a reasonable man conclude that the facts necessary to his case exist, and then the further burden of persuading the tribunal to believe that evidence, despite all contradictions. This is a handicap. A trial is no debate. The defendant has no legal need to make a case to win, unless the plaintiff makes a case against him first. Such is the theory of our law. The sleeping dogs will lie, unless the plaintiff finds power in his foot to stir them. There is no inherent virtue in this theory. Other systems have dealt otherwise. The popular mind still feels an accusation to have elements of proof. One might in proper circumstances draw from experience quite as well a rule that claims are not made without cause, and so handicap the defendant with the burden of clearing himself. And in a closer-knit community, where false charges would probably be known, and even more probably be frowned upon, where charges made would come attested by a suit of people evidencing the plaintiff's good faith by their presence, this has been done. Our present theory, however, is as described above, and in a loose-knit community of shifting, distant contacts, this handicapping of the plaintiff seems wise enough. So, likewise, in the main, do the lesser incidental handicaps one meets throughout the trial. Presumptions. If the plaintiff proves making and possession of a note, then it is presumed that he gave value for it, and came by it honestly, and has not yet been paid. The handicap, although it is a lesser one, runs against the defendant now. He must lift the burden of showing enough against such presumptions to force the plaintiff to his proof. This, you can see, is sense. This trial is made to profit by the experience of the cases of the past. At various times in all this trial procedure questions come up which we have glanced at, but which it pays to remember here. When the plaintiff's story is concluded, the defendant may test its adequacy in law. Even granting that everything he says is so, with all the inferences a reasonable man could draw from it, so what? This is the motion to dismiss. That motion may be made, too, at the end of the testimony. Or either side may ask for a directed verdict or judgment as a matter of law, which comes to this. On all the evidence, even when read most favorably to my opponent, no reasonable man could see facts which get in the way of my victory. His case is completely insufficient. Mine is completely sufficient. You will observe again that all of these questions deal with hypothetical, not actual, states of fact, yet with the legal consequences of such hypothetical facts. One thing more. In about half our states, if both sides ask for a directed verdict, the jury disappears from the case, and the court, so to speak, by mutual consent takes over the determination of what the true facts shall be assumed thenceforth to be. Once the jury has rendered its verdict, or the court has, so to speak, acting as a jury done the like, the legal situation changes. From then on, providing only first, that the proper etiquette has been observed throughout the trial, and second, that enough evidence is present to support a finding by that omnipresent hypothetical, reasonable man, who rules our legal theory, conflicting evidence on all material points has been resolved for keeps against the losing party. We have therefore moved one farther step away from the reality of raw events. From now on, the facts of this case, for purposes of anything that will be done at law, are settled. Whatever facts are needed to support the verdict, and are themselves supported by the evidence, are for this case the facts. And this is the situation presented by a motion for judgment, notwithstanding the verdict, or for judgment as a matter of law, after a verdict is decided. Not, even if the facts were ruled against me, but, even although the facts have been ruled against me, and on all points, those facts still show my right in law, and not my adversaries. But you will see how many weaknesses in a case, and indeed, how many slips made by counsel in trying a case, a verdict will cure, if it is once obtained. Any facts the pleadings and evidence would permit to be found are now by main strength treated as if found, if that is necessary to sustain the verdict. One last point. If what is objected to is an alleged departure from the proper rules of trial, the losing counsel must normally give the trial judge a chance to correct his own error before making an appeal. He moves for a new trial, moves to discard the old trial and start over. If he is right, this will save time and trouble. a ruling which the judge has made in error in the pressure of the trial he may perceive, when more at peace, to have been wrong. But if the loser does not prevail in this, the judge will enter judgment. The losing party, within the fixed time set for the purpose, can now appeal. If he does not, there is the matter of enforcing judgment. If the defendant won, and if he has not filed a counterclaim, a claim against the plaintiff like the plaintiff's against him, the judgment for him will cover only so-called costs, the fees for filing papers, and for the jury. Perhaps a nominal sum supposed to cover his expense for counsel. If the plaintiff wins, typically he has become entitled either to be put in possession of land or to a sum as damages, or both as well as costs. The sheriff, when proper application has been made, will order the defendant off the land and put the plaintiff in. The order ordinarily will be enough. Even the order will be hardly needed. Defendants have no wish to go to war against the state. But with the damage judgment things are different. For it can be realized, even when the sheriff has been duly called upon, only by seizing goods or land of the defendant. They must be found to be seized. They must exist to be found. Here again procedure conditions substantive law, not only in that you must know what to do and do it right, but this time also in that there must be something to be done, some assets of the defendant for procedure to work upon. Sumner, in one of the neat turns that mark his essays, hits home on this. A man who has no property may break his contract with impunity. However, these troubles with the sheriff, which do afflict the man with property, can commonly be staved off by an appeal. And why can he appeal? Observe, pray, that his appeal is brought at a heavy price. But not to him. His power to appeal is simultaneously a right to delay for more long months the realization of a just claim by his adversary. Security, by an appeal bond, the adversary may demand. But security solves the problem only half. The appeal remains as a power to put the adversary to time and trouble and expense. Assuredly, this is not the purpose of the power. That purpose looks to an adversary who never should have had temporary success below. But note the expense and delay of dilatory appeals as you meditate upon the values of the proper ones and raise the question in your minds for pondering. Is there no way of having what good this gives at lower social cost? What is that good? Why do we recognize appeals? I suspect chiefly, if not entirely, because there is more than one trial judge within the state. More than one trial court means two things. The first is that where several men hold like jobs, no matter how good they are, there is always a chance of getting a smaller group of better men. Or when, as so long in England, the several men sit separately, and under pressure of business, they may be able to do materially better on difficult problems if they sit together, and at leisure. All of this looks to deciding this case right. There is a strong feeling, which seems to lie deep in human nature, that disputes at law should be decided right. At the very worst, that they should be decided right within the presuppositions and the terms of the particular legal system in which they are decided. And indeed, some legal systems have at times attempted no more with the appeal than this. Some again have not been so much worried with this problem. It was not till 1907 that appeals in criminal cases were allowed in England. But there is another result of having several trial courts. Distinct, however closely related to the first. Different trial courts, indeed different appellate courts, different coordinate courts, in short, will inevitably from time to time decide like cases in different ways. This is uncomfortable. Partly, people like to think of the law as definite even while it is not. Partly, many people have an idea there can be but one right solution of a legal problem. Partly, it is much harder to arrange affairs with an eye to what courts will do, when different courts before which a matter may be brought will with some certainty act differently about it. One of the grand functions of the appeal, and of a single Supreme Court to which to appeal, lies certainly in the reducing of this difficulty. Reducing, not eliminating. It is still present. Except that we are hardened to it, we might say present in alarming measure. It is present, as among the several states, under our system of 50 distinct civil, criminal, and commercial jurisdictions. It is present as between state and federal courts in some instances. It is, despite state supreme courts, present to a large degree within the states. Judges do not cease to be human because they wield a gavel. Divergencies in training, ability, prejudice, and knowledge still occur and lead to differences in the results upon like facts. Yet the Supreme Court and the appeal to it go far to limit the trouble. One excellent evidence we have in the history of Georgia, which for half a century struggled on with trial courts alone. Divergent decisions drove the judges there into informal conferences to iron out their differences. They would not iron out. Some men are stubborn. A Supreme Court was finally introduced. Once introduced, it had come to stay. The need, I may say in passing, was clear some 30 years before the plaster was applied. This gives suggestion of the speed of basic law reforms. I have said that these two reasons for having courts of review were not the same. Certainly not in their tendencies. For if the main job be to get this individual case decided right, it should go up on law and facts and both together. Ideally, there should be a new trial entire before the upper court. Short of that, to save time and duplication, the whole written record should go before the reviewing body. And they should have power where things seemed doubtful or obscure or overlooked to call new witnesses. And some such procedure was in vogue in Germany. Some such procedure was the practice of the English Chancery. Some such procedure, although without the procurement of any further light that may seem needed, is the procedure before the Appellate Division in New York. But if the main job be to fix a single practice for all the trial courts of the territory, then a review of the facts, of the doubtful testimony, even a review of all the details of admitted facts, in reference to the legal consequences, seem to lose their importance. What looms large is the rule to be laid down a general proposition. The facts seem relevant only in highly abstracted form, and only to build the general setting of the rule. The facts of the case in hand, be they admitted or contested, seem interesting chiefly as illustrating one of 1,000 possible applications of the rule. So we have the highest court of France presented with the most painstakingly abstract of problems, and those of Germany and of New York explicitly limited in theory in distinction to their own intermediate courts of review to questions of law and barred from consideration of questions of fact. The rule alone is for them to be relevant. They are to specialize in setting rules for all, so far the theory. Yet the facts are hardy weeds. They will not down. Whatever the theory, courts of review of pure law feel the pressure of the individual case and strain to decide it right. Judgment for the plaintiff runs the old anecdote of Marshall. Mr. Justice Story will furnish the authorities. And we have similar testimony in individual cases from many judges in many lands and times. From all this, two things follow. First, in approaching any case upon review, we need to know what the kind of review is, what the court is undertaking to do, or we shall fail to understand its action. And secondly, even when it in theory is confined to rulings on the law, we shall be somewhat canny as we watch its work, and look for evidence as to how far the proposition which seems so abstract has roots in what seems to be the due thing on the facts before the court. And from the second viewpoint, that making clear doubtful rules is the main job, we shall understand the growing tendency of our law to cut down on appeals, to deal with them not as matters of right, as things to which a man has claim merely because there is a lawsuit, but as matters primarily of public interest, which need occupy the highest court only when it arrives at the conclusion that a question of general interest is at stake. And we shall understand from this viewpoint also, and peculiarly why it is so necessary, in studying the case on appeal, to look for the particular lapse complained of. For it is only the claim that the lower court in some point has gone counter to the law, which gives the upper court a law point to review. When we turn now to what goes on in the appeal, we find again that most of it lies in the background, where we do not get to see it. The losing counsel gets together, from the proceedings below, a statement of the case. More accurately, a statement of so much of what came before the trial court as is necessary to make clear what he complains of. If the winning party will agree that he has stated the question fairly, that is that. If not, he must make a statement which the trial court will approve. To this, he adds as a brief what he complains of, his argument that, as the phrase goes, there was error, and that the error, if such there was prejudicial to him. For our courts do not sit to decide questions if they do not matter. To be sure that the question matters, the rule is clear, and it is rigorous. What is complained about, on the complainant's showing, must have hurt him, or had clear tendency to hurt him, in his legal rights. Finally, the appellant weaves into his argument the authorities on which his argument is based. The other party replies in similar fashion. The papers are printed, exchanged, submitted to the court, a court, this time, which regularly consists of more than one judge, to get the benefit of consultation. A court, this time, in which there is no jury, in which lay members wisely or unwisely do not sit. It may or may not occur, according to the practice of the court and the agreement of the lawyers, that over and above the briefs an oral argument is made, but whether it is or not, you do not get to see it. What do you see? You see the so-called case as reported from the court of review. Its name or style, the court that decided it, the date of decision, the briefest of statements as to how it got before this court, a summary of the facts, the names of the counsel on both sides, perhaps a listing of the points they made, even a summary of how they made them. The ruling of the court of review, and the opinion. Especially the opinion. Almost you can say, the opinion for purposes of case books is the case. What then is the opinion? It is the justification, prepared by one judge whose name it bears, and concurred in by the court, for the courts deciding the case as they have done. How it comes into being differs from court to court. Sometimes there is a consultation, and if possible a decision of the case before any opinion is prepared. Sometimes one judge is assigned before consultation to report upon the case, and brings in as a report what, if all goes well, will then be the opinion. Sometimes the opinion is viewed by the whole court as its own responsibility. The opinion of the court, delivered by Judge X. Sometimes the court purports only to render judgment, without too heavy obligation to the reasons as put forward by the judge who writes. Always, however, the opinion is an explanation, a justification of the decision, and one at least acceptable to the court which decided. Almost always the opinion is all that you see. Behind it lies the whole course of transaction, trial and appeal, which has been sketched. And one vital point is here again to be hammered home. Obviously, the case cannot be decided, or rather the bearing of the decision cannot be made plain, nor the decision justified, without some statement of the facts. That is, of the facts the court assumes, adopts as the basis for its decision. Sometimes the judge prepares the statement himself, whether he writes it into the opinion or prints it before. Sometimes it is prepared by the reporter, be he an official of the court or a private observer who gets the decision ready for publication. But whoever prepares it, it is prepared with reference to the opinion. And peculiarly, if the judge prepares it, it is prepared to make the opinion look sound, look right, persuade. What is the relation of this statement of the facts to the brute raw events which happened long before? What is left in men's minds as to those raw events has been canvassed, more or less thoroughly, more or less skillfully, by two lawyers. But canvassed through the screen of what they considered legally relevant, and of what each considered legally relevant to win his case. It has then been screened again in the trial court through the rules about what evidence can be admitted. The jury has then reached its conclusion, which for purposes of the dispute determines contested matters for one side. The two lawyers have again sifted, this time solely from the record of the trial, what seemed to bear on points upon appeal. Finally, with a decision already made, the judge has sifted through these facts again, and picked a few which he puts forward as essential, and whose legal bearing he then proceeds to expound. It should be obvious that we may now be miles away from life. Again, we may not. By some miracle it may be there is no distortion. Or by some other each successive distortion may have neatly cancelled out the last. But it is current doctrine that the age of miracles is past. Yet even if all I say and hint is true, that in no slightest part destroys the value or the power of the court's opinion. For the decision plus the opinion go far to show what this court that speaks will do again upon like facts to those assumed. They are the court's pronouncement as to what we may expect. From the side of orienting ourselves to what the court will do, they are essential. Moreover, the court in its opinion has laid down a rule or 5. These too have been pronounced as things we are to reckon with. We shall do well to heed them. On the other hand, 2 things this long-continued sieving of the facts through different screens has hidden from us. In the very last of the sievings, that undertaken by the judge who wrote the opinion, we have had removed from our sight a very considerable number of hard facts, which may, for all we know, have much affected the actual outcome of the case. I pointed out before that even an appellate court officially concerned with rules alone has been known repeatedly to strain itself, and to strain the rules that it laid down in order to produce what seemed a just result in the case in hand. Put differently, although the outcome in the case may be and commonly is a function of the rule laid down, the rule laid down may be and commonly is a function of the outcome of the case partly sought for, shaped and phrased for the purpose of justifying the result desired. Now, so far as facts are factors not shown in the report or at work in the court, and so far as they really bore upon the outcome, the opinion gives us a misleading picture of what happened, and therefore a misleading basis for prophecy of what will happen in the future. Fortunately for us, however, the basis for prophecy is somewhat firmer than is the record of what happened in the case. Fortunately for us, we know that judges will, in future cases, take account of what the opinion records pretty largely, as if the opinion itself contained a true record of the events. To that extent, they in their canvassing of what has been done in the past in order to predict or to influence their decision in the new case, and we in our canvassing of what has been done in the past in order to predict or to influence their decision in the new case, will be working with a common equipment on a common basis. Yet in another aspect of prediction, the facts which the judge has hidden from us consciously, or as in most cases, unconsciously, are badly needed. For we may expect that in future cases, as in the case in hand, one of the possibilities will be that rules will be twisted out of their apparent shape in order to produce what seems a just result. In order to reckon with that possibility, it is vital to us to see something of the twisting that has gone on in the past, to get at its extent, at its nature, at the facts which have induced it. I shall have more to say on this when I come to a discussion of dissenting opinions. At this time, I wish merely to remind you that here is an aspect in which the judge's justification for the decision often may, and often will prove to be inadequate, if taken as a description of how the decision really came about, and of what the vital factors were which caused it. But even more has the long-continued sifting of the facts hidden from us another aspect of what we would gladly be equipped to gather from the case. I have said before that we could measure the meaning, either of rules of law or of the actual decisions of the courts, could measure their meaning in life, only as we observed what difference these rules and these decisions made to people. And every law case is obviously an instance where the court's behavior has had an influence on people. But the influence on people cannot be gathered with any sureness from the hypothetical states of fact, with which, too often, the issue in the case presents us. The influence on people and our understanding of it depend upon what I have described as the brute events outside. If we are to understand what the rule means, then we must typically go far outside the opinion. We cannot typically trust the facts given in the opinion all the way, even as a record of a single concrete instance of what the rule has meant. This is not always true. Or better, there are cases in which this typical situation happens by good fortune to be absent. There are cases in which the facts recorded in the opinion carry what historians would call internal evidence to guarantee that they are really close to life. Such cases deserve your careful study of the facts as such, over and above their relation to the action taken by the court. But in other cases your hunger must be directed partly to something not found in law books, but lying beyond and still to be explored. In this discussion of what lies behind a case as it appears in the opinion, I hope it has become clear to you that through all the technicality of mere procedure, there run threads of purpose, sane purpose, useful purpose. Indeed, I find it very difficult to imagine your ever coming to grasp these technicalities and to master them unless you keep in mind these threads of purpose as the strings to thread your single beads upon. Save for a recognition of the job's procedure has to do, the rank growth of technical detail becomes impassable. Yet, I hope, on the other hand, that it has grown clear that purpose alone is no guide through procedure. It is no guide through any human institution. The nature of institutions is that they grow around our needs and partly serve them. The nature of institutions is also that they almost never serve those needs to satisfaction. Hence, all the detailed technique of our law procedure is not only better seen, but better judged by following the purposes concerned. In their light, and in their light, only you see whether the technique is a good one or a bad, a wasteful one or an efficient, a fossil or a living organ. Yet to know it as a fossil, as an instrument of impediment, delay, confusion, is not to remove it from the scene. It is there. You see it more clearly and know better how to reckon with it when you know how and how far it is out of its due place and in the road. But regard it you must. It stands between you and a successful conclusion of your case. Challenge it, you may. If you have any sense of what your profession owes to our society, challenge it you will with such skill as you know. But overlook it you may not. It is there, a part of your environment, to be reckoned with, to be worked with, or to be challenged. And to be reckoned with, worked with, even while you challenge it.